Thank you very much, Mr. Chairman. Good morning, Judge.
Thank you.
I'm sorry about the circumstances, but we'll get through it. I wanted to talk to you this morning about guns and go back to Roe v. Wade, if I might. My office wrote the assault weapons legislation in 1993. It was law from 94 to 2004. And it essentially prohibited the transfer, sale, and manufacture of assault weapons. It did not, at the time, affect possession. I happen to believe that it did work and that it was important. And I have watched case after case, and I think I mentioned earlier, school shootings, which are just, I never thought this would happen in our country, that someone would bring a semi-automatic assault weapon into a school and just mow down children and staff. And so I've been very interested in your thinking on assault weapons. You specifically argued that the D.C. assault weapons ban was unconstitutional, and I think because you said these weapons were in common use. What did you base your conclusion that assault weapons are in common use? And what evidence or study did you use to do that?
Thank you, Senator Feinstein, for the question. And I understand, of course, your role on that issue and your long leadership on that issue, and appreciate that. I faced a decision where, as in every other decision just about on the D.C. Circuit, I had to follow precedent of the Supreme Court. I don't get to pick and choose which Supreme Court precedents I get to follow. I follow them all. And so in the Second Amendment context, the Supreme Court in the Heller decision, written by Justice Scalia, had held that there was an individual right to keep and bear arms. And then in explaining what that meant and what exceptions would be allowed to that right, Justice Scalia's opinion for the court in Part 3 of the opinion went through, this does not mean that there's no gun regulation permissible. So that was an important part of the opinion, Part 3 of the Supreme Court's opinion, where it pre-identified a number of exceptions that would be allowed. Felon in possession laws, concealed carry, laws, possession of the mentally ill, possession of guns in schools, possession in certain kinds of buildings. He pre-identified that. As to the weapons, the way I understood what he said there and what was said in the McDonald case later was that dangerous and unusual weapons could be prohibited. And what he referred to specifically is machine guns could be prohibited. So it's very important to recognize under the Heller decision, machine guns can be prohibited. And
they were in the Firearms Act a long time ago.
Yes, and that's
have been prohibited.
Yes, Senator, and Justice Scalia's opinion did not disturb that long-standing regulation. In fact, specifically reaffirmed that machine guns could be prohibited. The court in Heller, the Supreme Court, upheld or struck down a D.C. ban on handguns, most of which are semi-automatic.
Let me interrupt you because I think we're on totally different wavelengths. I'm talking about your statement on common use, as common use being a justification, and assault weapons are not in common use.
And Justice Scalia's opinion used that phrase. Then I think the next sentence of the opinion talked about dangerous and unusual weapons. And the court in Heller itself, the Supreme Court, struck down a D.C. ban on handguns. Now, most handguns are semi-automatic. That's something that not everyone appreciates. Most handguns are semi-automatic. And the question came before us of semi-automatic rifles, and the question was, can you distinguish as a matter of precedent? Again, this is all about precedent for me, trying to read exactly what the Supreme Court said. And if you read the McDonald case, and I concluded that it could not be distinguished as a matter of law, semi-automatic rifles from semi-automatic handguns, and semi-automatic rifles are widely possessed in the United States. There are millions and millions and millions of semi-automatic rifles that are possessed, so that seemed to fit common use and not being a dangerous and unusual weapon. That was the basis of my dissent. In a nutshell, the basis of my dissent was I was trying to follow strictly and carefully the Supreme Court precedent. And I know you've read the opinion.
You're saying the numbers determine common use? Common use is an activity. It's not common storage or possession, it's use. So what you said was that these weapons are commonly used. They're not.
They're widely possessed in the United States, Senator, and they are used and possessed, but the question is, are they dangerous and unusual? They're certainly dangerous. All weapons are dangerous. Are they unusual? And given how prevalent they are in the United States, it seemed under Justice Scalia's test, and if you look at the majority opinion in McDonald, the same thing. I want to reiterate, the Supreme Court made clear that machine guns can be banned. Machine guns can be banned.
Let me speak to you. I'm talking about the Heller case. Let me be specific. And you specifically argued that it was unconstitutional to defend assault weapons because they are, to ban assault weapons because they are in common use. And that, I believe, was your dissent in the case.
Yes, and I was referring to some kinds of semi-automatic rifles that are banned by D.C. are in widely owned in the United States. And that seemed to be the test that the Supreme Court had set forth in the Heller and McDonald cases. In other words, if a type of firearm is widely owned in the United States. Now, whether I agree with that test or not was not the issue before me. I have to follow the precedent of the Supreme Court as it's written. And that's what I tried to do in that case. It's a very long opinion. I also made clear, Senator Feinstein, at the end of the opinion, I am a native of this area. I'm a native of an urban, suburban area where I grew up in a city plagued by gun violence and gang violence and drug violence. So I fully understand, as I explained in the opinion, the importance of this issue. I specifically referenced that Police Chief Kathy Lanier's goals of reducing gang and gun violence was something I certainly applauded, but that I had to follow the precedent of the Supreme Court in that case. And as I read it, that's what it said. I'm sorry.
How do you reconcile what you've just said with the hundreds of school shootings using assault weapons that have taken place in recent history? How do you reconcile that?
Senator, of course, the violence in the schools is something we all detest and want to do something about. And there are lots of efforts, I know, underway to make schools safer. I know at my girls' school, they do a lot of things now that are different than they did just a few years ago in terms of trying to harden the school and make it safer for everyone. Handguns and semi-automatic rifles are weapons used for hunting and self-defense, but as you say, Senator, you rightly say, they're used in a lot of violent crime and cause a lot of deaths. Handguns are used in lots of crimes that result in death, and so are semi-automatic rifles. That's what makes this issue difficult. As I said in the last 2 pages of my dissent in Heller, I fully understand the gang violence, gun violence, drug violence that has plagued various cities, including Washington, D.C. This was known as the murder capital of the world for a while, this city, and that was a lot of handgun violence at the time. And so I understand the issue, but as a judge, my job, as I saw it, was to follow the Second Amendment opinion of the Supreme Court, whether I agreed with it or disagreed with it. At the end of the opinion, I cited Justice Kennedy's Texas versus Johnson quote, which I read yesterday as the guiding light for the lower court judges and all judges.
Let me give you a couple of other quotes because I'm going to change the subject. Do you agree with Justice O'Connor that a woman's right to control her reproductive life impacts her ability to, quote, participate equally in the economic and social life of the nation, end quote.
Well, as a general proposition, I understand the importance of the precedent set forth in Roe v. Wade. So Roe v. Wade held, of course, and it's reaffirmed in Planned Parenthood versus Casey, that a woman has a constitutional right to obtain an abortion before viability, subject to reasonable regulation by the state, up to the point where that regulation constitutes an undue burden on the woman's right to obtain an abortion. And one of the reasons for that holding, as explained by the court in Roe and also in Planned Parenthood versus Casey more fully, is along the lines of what you said, Senator Feinstein, about the quote from Justice O'Connor. So that's one of the rationales that undergirds Roe v. Wade. It's one of the rationales that undergirds Planned Parenthood versus Casey.
Well, let me give you another one, rationale. In the 1950s and 60s, the 2 decades before Roe, deaths from illegal abortions in this country ran between 200,000 and 1.2 million. That's according to the Guttmacher Institute. So a lot of women died in that period. So the question comes, and you have said today, not today, but it's been reported that you have said that Roe is now settled law. The first question I have of you is, what do you mean by settled law? I tried to ask earlier, do you believe it is correct law? Have your views on whether Roe is settled precedent or could be overturned? And has your views changed since you were in the Bush White House?
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years, as you know. And most prominently, most importantly, reaffirmed in Planned Parenthood versus Casey in 1992. And as you well recall, Senator, I know when that case came up, the Supreme Court didn't just reaffirm it in passing. The court specifically went through all the factors of stare decisis in considering whether to overrule it. And the joint opinion of Justice Kennedy, Justice O'Connor, and Justice Souter at great length went through those factors. That was the question presented in the case.
Could I interrupt you to say, since you mentioned stare decisis, and I sat on 9 of these hearings, and when the subject comes up, the person says, I will follow stare decisis, and they get confirmed, and then, of course, they don't. So I think knowing going into it how you make a judgment on these issues is really important to our vote as whether to support you or not, because I don't want to go back to those death totals in this country. And I truly believe that women should be able to control their own reproductive systems within, obviously, some concern for a viable fetus.
Mm-hmm. And I understand your point of view on that, Senator, and I understand how passionate and how deeply people feel about this issue. I understand the importance of the issue. I understand the importance that people attach to the Roe v. Wade decision, to the Planned Parenthood versus Casey decision. I don't live in a bubble. I understand. I live in the real world. I understand the importance of the issue.
Well, my staff just passed me a note. Let me read it to you because I think it's a good. Have your views about whether Roe is settled precedent changed since you were in the Bush White House?
My
yes or no?
Well, I'll tell you what my views. I'm not sure what it's referring to about Bush White House, but I will tell you what my view right now is, which is an important precedent of the Supreme Court that's been reaffirmed many times. But then and this is the point I want to make that I think is important, Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. It's not as if it's just a run-of-the-mill case that was decided and never been reconsidered, but Casey specifically reconsidered it, applied the stare decisis factors, and decided to reaffirm it. That makes Casey a precedent on precedent. Another example of that, because you might say, are there other cases like that, is Miranda. So Miranda's reaffirmed a lot, but then in the Dickerson case in 2000, Chief Justice Rehnquist writes the opinion considering the stare decisis factors and reaffirming Miranda, even though Chief Justice Rehnquist, by the way, had been a fervent critic of Miranda throughout his career. He decided that it had been settled too long, had been precedent too long, and he reaffirmed it. So precedent on, I'm sorry to interrupt.
I'm sorry to interrupt.
Thank you.
But I want to switch subjects, and one last question. What would you say your position today is on a woman's right to choose?
As a judge,
As a judge.
it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember. And I understand the significance of the issue, the jurisprudential issue, and I understand the significance as best I can. I always try, and I do here, of the real-world effects of that decision, as I tried to do of all the decisions of my court and of the Supreme Court.
Well, I thank you for that. Let's go to presidential power for a moment. You were part of Ken Starr's independent counsel team, which conducted a sweeping investigation into possible wrongdoing by President Clinton and the First Lady. At the time, you argued for aggressive questioning of the president. You did not take the position that President Clinton was immune from investigation. Since then, you have taken the opposite position. In fact, you have said that, and I quote, "If the president were the sole subject of a criminal investigation, I would say no one should be investigating that at all." What did you mean by that? And what are the circumstances where a sitting president could be subject to criminal investigation?
And I appreciate the sign there. Senator, the last sign I should have mentioned while I was up, the Second Amendment sign actually had a brackets around part of my quote, and I'm not sure if it was the exact quote, but this one, I just wanted to point that out.
Is this accurate?
Here's what I was saying, Sarah. Let me explain it. This one. The last one may or may not have been accurate. I just wanted to point that out for the record. It had brackets for my quote. This one. So what happens after the Starr investigation? Then I work 5.5 years in the White House. So let me just give you, if I can, some context here, and I'm going to get specifically to your question. So I work in the independent counsel investigation, and that is obviously difficult, controversial, a moment for our country that I wish hadn't happened. We all wish it hadn't happened. And I reflect on that. I wrote a Georgetown University Law Journal article in '99 reflecting on some of my thoughts about that. This seems to be a tendency of mine to go through an experience, write an article reflecting on it. And then I work in the Bush White House for 5.5 years. And I write an article in the Minnesota Law Review, Senator Klobuchar, in 2009, when President Obama's in office, I should point out. And I reflected on a number of things I had learned working in the independent counsel office and then working in the White House. And I thought there were a number of things Congress could take a look at that I had experienced. One of them was I proposed timelines for consideration of judicial nominees. I proposed a 180-day up or down vote for every judicial nominee. That was something that, from my experience, I thought would avoid controversy and have rules of the road set in advance, and I proposed that specifically for Congress to consider. Other aspects, I said, another thing I proposed was for Congress to consider whether it should look at Clinton versus Jones or the principle of Clinton versus Jones. So you call Clinton versus Jones and said a president is subject to civil suit while in office, the Paula Jones suit. That was a controversial decision, but the Supreme Court made clear at the end of the decision Congress could provide extra deferral of suits, not immunity, but deferral of suits for presidents if Congress so wanted. And so in the Minnesota Law Review article, I put out some ideas about whether Congress may want to think about that. And why did I do that? I think Senator Durbin asked yesterday, what changed that made me think about that from the time? What changed was September 11th. That's what changed. So after September 11th, I thought very deeply about the presidency. And I thought very deeply about the independent counsel experience. And I thought very deeply about how those things interacted. And I thought very deeply about seeing President Bush. When he came into the Oval Office on September 12th, 2001 in the morning, President Bush said, "This will not happen again. This will not happen again." And he was of single-minded focus. Every morning for the next 7 years for President Bush was still September 12th, 2001. Single-minded focus. And then thinking back to the independent counsel experience in August of 1998. So I proposed some ideas for Congress to consider. Here's the bottom line point. There were ideas for Congress to consider. They were not my constitutional views. If a case came up where someone was trying to say this is a constitutional principle, I would have a completely open mind on that because I've never taken a position on the Constitution on that question. I've only put out proposals for you all to study, to think about the balance of a president fighting a war, leading a war, and a president subject to, say, ordinary civil lawsuits as in the Clinton versus Jones case.
Let me ask you, you're becoming very good. You're learning to filibuster. But let me ask this question precisely. The Supreme Court has unanimously ruled that a president can be required to turn over information. It upheld the subpoena for the tapes of Oval Office conversations that revealed President Nixon's efforts to cover up the Watergate break-in. This, as you know, was U.S. v. Nixon. You have said that the Nixon case might have been wrongly decided. Was U.S. v. Nixon wrongly decided, in your view?
So that quote is not in context and is a misunderstanding of my position that's up there. I have repeatedly called U.S. v. Nixon one of the 4 greatest moments in Supreme Court history. So I've called that, the 4 I've always identified are Marbury versus Madison, Youngstown Steel, Brown versus Board of Education, and United States versus Richard Nixon. And why have I, Brown versus Board, by the way, the single greatest
Was
moment.
it rightly decided?
So I have said that, I've said yes, that the court's holding that a criminal trial subpoena to a president in the context of the special counsel regulations in that case for information, a criminal trial subpoena for information under the specific regulations in that case, I have said that holding is one of the 4 greatest moments in Supreme Court history. So not only I can explain how that misunderstanding came up, because I know there was a news story about that, and that's just not correct impression of my views. My views have been consistently. Why was it one of the greatest moments? It was one of the greatest moments because of the political pressures of the time. The court stood up for judicial independence in a moment of national crisis. That's what the Supreme Court, we need the Supreme Court to decide the things we can foresee. But one of the things that's really important for the Supreme Court, we're going to have crisis moments at the Supreme Court on things we can't even predict. And we need people on the Supreme Court who are prepared for that. And U.S. v. Nixon is...
My time's going to run out very quickly. Let me just ask you this. Can a sitting president be required to respond to a subpoena?
So that's a hypothetical question about what would be an elaboration or a difference from U.S. v. Nixon's precise holding.
That's right.
And I think going with the Justice Ginsburg principle, which is really not the Justice Ginsburg alone principle, it's everyone's principle on the current Supreme Court. And as a matter of the canons of judicial independence, I can't give you an answer on that hypothetical question.
So you can't give me an answer on whether a president has to respond to a subpoena from a court of law?
As my understanding is that you're asking me to give my view on a potential hypothetical, and that's something that each of the 8 justices currently sitting on the Supreme Court, when they were sitting in my seat, declined to decide potential hypothetical cases. I can tell you about the U.S. v. Nixon precedent, and I did, about Chief Justice Burger's role in forging a unanimous opinion, and really all the justices worked together on that. But Chief Justice Burger, who had been appointed by President Nixon, writes the opinion in U.S. v. Nixon, 8-0, Rehnquist was recused, 8-0, ordering President Nixon to disclose the tapes in response to a criminal trial subpoena. A moment of crisis, argument, I think July 8th, 1974, they decided 2 weeks later. Really important opinion. Moment of judicial independence. Important precedent of the Supreme Court. But how that would apply to other hypotheticals, I best, as a sitting judge and as a nominee, follow the precedent of the nominees who've been here before, and as a matter of judicial independence, not give you a precise answer on a hypothetical that could come before me.
Understand. Thank you very much for being forthcoming. Appreciate it.
Thank you,
Mr. Chairman.